What the heck is happening in HR is so happy to welcome back Alejandro Perez. Alejandro is coming back, but with a new firm. He is a partner at Pearson Ferdinand LLP. He is a labor and employment attorney. He represents employers in a wide array of workplace law matters, from day to day advice to counsel to litigation. And in the practice, he defends employers of all sizes against discrimination, harassment, retaliation, wage and hour, wrongful termination, and all those other claims that can come out of an employment relationship. He also loves the fact that he loves learning about his clients' businesses, works closely with them, and helps even create those HR policies and best practices to minimize any risk and increase job satisfaction. He works a lot with disabilities and Title III of the ADA and some sensitive workplace investigations. He travels across the country speaking and training, and we are so glad he is here because he has been just brilliant with us in the past, and we are expecting more about that now from him. So, welcome back, Alejandro. For our podcast disclaimer, please visit the episode description. Thanks so much for coming back to What the Heck is Happening in HR. And today we have a returnee, one of my favorite attorneys. They're actually all my favorite, but I won't tell Alejandro Perez. I'll let him know that he's my favorite. And we're going to have a great chat today. So thanks for coming back, Alejandro.
Oh, it's my pleasure, Kelly. Thanks for having me. And you're my favorite too.
Oh, yeah, there you go. You say that to all of them. And here we are at the USF podcast studio as we have this. And I know it's a place near and dear to your heart.
It absolutely is. I'm a bull, and I grew up in Tampa, Florida. Although I currently sit in Phoenix, I always am happy to get back to home. And even I'm here virtually today, I'm still, kind of tingling to be back.
You are. So go Bulls. So
Yes, go Bulls.
something exciting, and being an HR geek, I was very excited about. And as I shared with you recently, that no one in my house could understand why I was so excited about this, and that is what happened with the Chevron doctrine. So let me just run my own little test and tell me if this is true. So the Chevron doctrine means basically that federal courts would, if there was like unclear as to whether it should go towards the employer or go towards what the federal agency said, they were kind of compelled to follow the federal agency, even if it was ambiguous. Is that it?
Correct. So what happened is, so the case, so they were discussing now, which is Chevron v. Natural Resources. It gave deference to agencies, right? So long as the agency interpretation was reasonable, right? But you're absolutely you're right to think, and you're probably right to be happy. I'm sure most employers are, right. Loper Bright Enterprises versus Raymundo, the case that has dismantled Chevron deference. So that is a really interesting turn of events, and it's really going to impact how agencies function in the future.
So let's talk about that. What difference does it make to me as a business and as an HR person?
Right. So let's go back to what Chevron is, right? So it gave deference to agencies. What that means is, if we had a rule that was, really was subject to some sort of ambiguity, the agency would come in and say, this rule means X, Y, and Z. And courts were bound for over 40 years to apply and to acknowledge and give deference, hence the term Chevron deference, to the agency. Now that's gone completely out the window. Courts can, I guess arguably courts now can take into consideration an agency's view, but they are not bound to apply it under any circumstance. So as you can imagine, that's a huge change, right? It's going to reshape the employment law sphere. Really, really will. Because, right, so on one hand, people were like, Congress created these agencies to do their job, and the agencies should have input, substantial input into the interpretation of the laws that they've been created to protect. However, personally, and maybe you would agree, and I think most people in our world would agree, the agencies really became emboldened and passed some really far-reaching laws that really negatively impact the workplace.
Mhm. And
Yeah.
so, whether it's negatively or not, this could impact something like the non-compete, issue that's hanging out there with the FTC, or even that change effective January 1 with Fair Labor Standards. Are those 2 kind of both up in the air because of this?
They're not up in the air so much, but they will be for sure, right? If we have injunctions in place, this rule is definitely going to the extent there's preliminary injunctions that have been placed against them, this rule is definitely going to come in now and probably further support the court's position against those that say that they're illegal. You're absolutely right. We're looking at, the EEOC's passing the Pregnant Workers Fairness Act could be under scrutiny. All of the National Labor Relations Board decisions that are, really getting into the employment relationship
Yeah.
are going to be, think of like all of the alphabet soup: EEOC, the Department of Labor, OSHA, the NLRB, all of that is going to be really under scrutiny now, and it's going to. I think it's potentially going to cause some headaches for employers too, Kelly, because right now it's going to be largely like state by state or district by district federally, where we may have inconsistent, incongruent laws where for the same statute.
Right, that's one of the things
Yeah,
I was thinking was it will depend on the federal court then
correct.
as to how that gets decided. So we certainly know that the 4th district's very different than the 9th, right? And then the 11th,
Right.
and so now we're going to have this whole conflict, and then what? That all rises back up to the Supreme Court again, or how does that work?
You got it. And I guess some people who are, I guess if you're looking at this a little more doctrinally, some people are very fearful that this could be the dismantling of personal rights on a federal level to begin with. I mean, that's a very, nuanced argument, but right, you're absolutely right. I mean, it's going to be called a circuit split, and then it could be essentially before the Supreme Court. So once again, so it can be, that part is difficult and it's hard to cognize. But just imagine in the interim of that, an employer having, a multi-state employer now has to really
Oh.
go by state to craft policies that are, that from state to state may conflict with one another.
And that that happens actually today, right? I mean, it
Yeah,
did. I mean, I remember when I had, was in the corporate world and we're saying, "How do we deal with this California law?" Where
correct. Oh, yeah.
and then how do we deal with this Iowa law? And
Right.
and what do we do? Do we change the benefit, that was being required by San Francisco for everybody, or do we only do it for the employees who are there? What do we do? And so there was that discussion even then. So now I'm thinking, oh my
Right.
gosh, you've got a whole bunch going on.
You're right, because there were some things that were just set in stone federally, right? So, I mean, states are free to make their own laws. And as you pointed out, California is probably one of the most stringent. However, when you look at, it's sort of exciting. I mean, from our perspective, right? And now it's going to say, things that were federally set in stone or may no longer be federally set in stone.
Mhm.
So states can change these things. And as we know, whether we want to admit it or not, the judiciary is largely a political body, and it's going to, whether or not they give deference to federal law through the agencies is going to really depend on come down to politics, right? And then there's sort of views with regarding state and federal involvement in state actions.
Yeah. Well,
Yeah,
personally, I love it when things head back to hearing the people. And
right.
so even if that makes it hard, I like it when we focus on everyone staying in their lane, if you will.
Right,
You
exactly.
know,
And right, I mean, you should be able, for states should be able to, that's a political conversation, but I agree with you. And I also think, more than that, the agencies have just been out of control, right? They have been like the FTC's non-compete ban. I mean, that is just to me unconstitutional, and it's really just an abuse of power by that agency to me, because they're, in some instances, a non-compete is very important for the protection of an employer.
Yeah, and then certainly the National Labor Relations Board, my goodness, we have had
Yeah,
just
yeah.
sweeping changes as to what are the rules.
There's sweeping changes and just really like an aggrandization of the rules in general, like an interpretation that is so far afield. For example, when it comes to like political speech, for example, the current general counsel of the National Labor Relations Board thinks that it's actionable and it's in concerted activity to even discuss personal politics at work. So I mean, we're really going out of just talking about our the confines of our employment relationship to like including any kind of speech whatsoever, which is not what anyone I think would say was intended by the act. Well, the general counsel thinks it was intended by the act, but I don't think anyone else would have that interpretation.
Yeah, well, we certainly have an active general counsel with the National Labor Relations
Yeah.
Board.
Yes.
That's
Yes.
for sure. And
Yes.
and but tell me what you would say to an employer who says, "Oh, thank goodness now we don't have to pay attention to those federal regs."
Well, nothing has changed with regards to the federal regs that are in place. What will happen is when we see challenges to those regulations, right? And we will. So as of right now, it's sort of business as usual. But what you need to look at is be very, very cautious about what's going on. You team up with legal counsel and make sure that you're watching, what's going on in the courts and in the legislature, right, in all the states that you operate in. And it's going to be much easier to challenge regulations that come out of agencies. So it's really going to reshape our business as in the human resources and employment law professionals.
So, this doctrine has been around for 40 years.
40 years, yes.
It's generational basically, right? When in at
Yeah,
least
it's been around forever. I mean, it was entrenched in our legal stare decisis. It was part of the gig, right? It was just understood.
so tell me, does the upcoming election have anything to do with it? Will it swing
You
back
know,
quicker than 40 years? I mean, what it will happen? Give me your
well, in
crystal
order for
ball.
this, right? So in order, like, let me look at my crystal ball. Is so in order for this to be undone, right? This is a Supreme Court mandate, so the legislature would have to be involved
Yeah.
now to make a change to that. What that would require, of course, is most likely a Democratic majority in the
Mhm.
Senate, and so that's to pass a law, which is not easy to do.
Right.
And then second of all, we'll see changes, right? Every time that we see a change in administration, we see a change in, the first thing that happens is the heads of the agencies are fired and replaced with someone that's whoever the president
Right.
is more in line with their vision. So we see that shift all the time, right?
Right.
What we're not going to be able to undo, however, though, is the agencies can't just come and say like, oh, now the NLRB is going to do this because this is what we want. They're going to have to reckon with this case,
Mhm.
that stripped them away from their deference. The new head of the agency or the president was not going to have much power to change that unless they do so, through the courts, which just take a very long, long time.
Yeah, one of the
Yeah.
cases I always, share and we talk a lot about in my
Hmm.
little HR law class is, that I teach for HR professionals and business
Uh-huh.
owners is Lilly Ledbetter, because I think it's such a
Right.
fascinating case, and to have it go all the way to the Supreme Court and have Ruth Bader Ginsburg say, "Congress, it's in your court." The
Right.
ball is in your court, and for them to go, "Hey, the law is the law, and it's equal as to how it is, and if you wanna change, we'll support the change, but you gotta change it. We're not gonna change
Right.
it here at the
Exactly.
court." And that's what this
Yeah.
sort of reminded me of, is that if there are things that need to be changed, it goes back to those representatives, for people to be able to have the say as to how they want that done.
You got it, Kelly. That's exactly it. I mean, is right. So I mean, if that's when our ability as citizens and our powers as citizens come to play, and we have to go out there and request things. We should not be going by court made law, right? I mean, it should largely be left to the state and the federal legislature to create laws
Yeah.
that are going to shape employment and shape all of us, all aspects of our lives.
And that's why we've got 3 branches, and here we are,
Exactly.
and Alejandro and I are both running for president, and so you can vote
That's
for us.
right. You better vote for us,
Yeah,
exactly.
but thank you so much for bringing, us the, kind of the livability of Chevron and, the deference and what
Sure.
it means today. So thanks so much for joining us today, Alejandro.
My pleasure. Thank you for having me.